Hi family and friends from 305 and 100 Pay. My name is Veronica. I want to give you a great welcome back to our channel and to one of our podcasts. Today we're going to be starting a new series. We're going to be getting into the legal matters of our company and how we can help you and how our lawyers help you in your case. Today we have with us Louis Guerra from the Guerra Law Firm. Louis, thank you so much for making the time.
Thank you for having me, Veronica.
Of course, it's a pleasure. So let's get into it. We're going to be talking about negligence and how the law changed after Florida Governor Ron DeSantis did some changes in the law. So can you please explain to us what happened?
Sure. So in March of this year, Governor DeSantis signed a new law which changed drastically the many aspects of what we call the negligence law in Florida. In many ways, he changed it in that affects individuals who are actually involved in accidents and how they could possibly recover. And so this is the most drastic change in the law that we've seen in over 50 years.
So what changes? Before March this year, a person could recover compensation even if they were just 10% at fault and the other person was 90, even if they had more fault. So what exactly changed? What's the difference?
So that's one of the, I think, the most important aspects of this new law is how it affects what we call the comparative negligence standard. So Veronica, imagine that you are involved in an accident and you are actually partially responsible for that accident. In the way the law was drafted since 1970, I believe, it was that I could recover not the portion of my injury that I caused, but certainly the portion of the injury that you caused. And it didn't matter how much involved in the accident or in the injury I was. So, for example, if I was involved and the jury concludes that I was 90% at fault for my own injury, I could still recover from you the 10% of my recovery for the 10% of the part of the injury that you caused me. That was the system that was in place in Florida for many years, and we call that a pure comparative negligence system.
But now things changed.
Now things have changed
Things are different.
Yes, things are different, unfortunately.
What happened, unfortunately?
So when Governor DeSantis signed this bill made it a law in March, he changed drastically this aspect, as well as many others that perhaps we could talk at another section in this series, but he changed it such that now, if the jury finds that I am more than 50% responsible for my own injury, then I can recover nothing from the individual who was also responsible for my injury, the individual or the entity, however it may be. So whereas before, if I was 51% or 52% responsible and you were 48 or 49%,
I will have to pay for that 48.
Exactly.
But now you're more guilty than I am, so I don't owe you anything?
Correct. Even though you were involved in my injury. Correct.
Okay. This is really interesting, but it's really subjective. Like, there's got to be a process, like a discovery process, because the insurance company will always try to prove the fault, so they will always try to prove that they don't have to pay. So what is this process? And it's really subjective. There's got to be a jury? How is it going to work?
Well, yes. Let me take a step back, because it's very interesting how this new law may actually affect insurance companies and an individual who is injured in an accident and what that individual may or may not do. So now, with this new law, Governor DeSantis has put a lot of power, a lot of authority in the hands of the insurance companies. The insurance companies now, in a case where an individual is actually partially at fault, is more likely to take that case to trial because they're betting that they could convince a jury that perhaps you were 51% responsible and then they don't have to pay you anything. Whereas an individual who may or may not have taken a case before because they were involved in their own accident, had some responsibility, now that individual, and some lawyers may think, well, that case may not be a great case because clearly the plaintiff had some involvement And who knows, a jury may conclude that he was 50% or more. No, thank you, I won't take that case. So what DeSantis has done is put the power back in the hands of the insurance company. So yes, to answer your original question, there is a subjective standard that applies when you have a trial. Whether I say I'm 50% or 0%, or you say that I'm 51%, who determines that?
There's got to be a jury.
Right, it's got to be a jury. That's why it's so important to, when you have a case, that you go see a lawyer who has had some trial experience and understands what occurs in a trial. Because no matter what the insurance company says, the person or the persons who decide whether or not you are at fault at all, or whether you're at fault 50% or more, is a jury. Those 6 people will decide the case. And obviously, the insurance company will try and bully you and try and bully your client, but at the end of the day, the jury will have to decide, and it is subjective.
Okay, so we definitely need a lawyer that plays a big role when it comes to facing a jury and convincing a jury that you have a percentage of guilt, that you can get your money back from your incident, slip and fall, whatever it was. But I wanted to ask you, do you think this law is fair? Do you think there's gonna be some changes in the future? Like, what do you think we can expect from the negligence system?
Well, I think the law is completely, totally unfair. I think the law, again, makes it more difficult for a person who's been involved in an injury, in an accident, to actually receive compensation for their injuries. It's going to scare some people from going to trial. It's going to scare some lawyers from taking cases, and it's giving a lot of power into the hands of the insurance company. What's going to happen with this law? This law has become now a statute. So before, the law was a common law, was decided by the Supreme Court of Florida, where we had a pure comparative negligence standard. Now it's a modified comparative negligence standard, as we had just discussed. And so it is the law. Courts must follow this law. And for the foreseeable future, it will be the law. However, what can possibly happen, I believe, this law is going to cause a lot of individuals who don't have the resources to pay for their medical expenses to go to, they must go get medical treatment anyway, and it's going to pass the buck on to the Florida taxpayers, because they're going to have to pay those medical expenses. So eventually, I think what will happen is either the law will be changed once we get a new governor, and or possibly, although less likely, the Florida Supreme Court will make come to a conclusion in a particular case that this law is unreasonable or affects the due process rights of potential claimants. I don't see that as really happening. I think it most likely will be the law until maybe a new governor comes and changes it.
Okay, so family and friends, what do we get from this? Definitely get a lawyer that has trial experience, because you may have to go to trial. And keep in touch with us, keep in touch with the laws. The laws are changing, so you may think that you can get a certain amount of money from your case, but you may not. So please be sure to always keep in touch with us and keep in touch with the law and with your lawyers, any case. So I will see you guys in another podcast. Make sure to leave your comment, leave your answers, leave everything. Just say hi to us. I want to thank again Louis for taking the time to be with us in this podcast, and I will see you guys from 305 and 100 Payne in another podcast with more legal service. Thank you.
Thank you for having me, Veronica.
Thank you, bye.